CR2220-755, State of Idaho versus Chad Guy Daybell, as well as CR 2220-838, State of Idaho versus Lori Noreen Vallow, now known as Lori Noreen Daybell. Present here in the Zoom hearing, I have Mr. Daybell present with his attorney, Mr. John Pryor. I have Mr. Wood, who represents the state in both matters. I also have Mr. Means, who represents Ms. Daybell. I've got the clerk, some IT people, and then I've also got Mr. Wright, who appears on behalf of some media outlets that have filed a brief regarding the issue that we're taking up here today. First of all, let me hear from everybody. Does anybody object to holding this hearing remotely via Zoom instead of in person? Mr. Wright?
No, sir.
Mr. Pryor?
No objection, Your Honor.
Mr. Wood?
No objection.
Mr. Means?
No objection, Your Honor.
All right. The court has also been made aware that there was no court reporter that was available to be here for this hearing. Does anybody object to this matter proceeding without a court reporter and just being recorded on Zoom, as well as the FTR that's here in the courtroom? Mr. Wright, are you okay with that?
Yes, sir.
Mr. Pryor?
Yes, Your Honor.
Mr. Wood?
Yes.
And Mr. Means?
No objection, Your Honor.
Mr. Means, one last question for you. It's my understanding it is not your preference, or it's not your client's desire to appear in person today, and that she's waiving her right today to appear for this hearing. Is that correct?
It is, Your Honor. Thank you.
With that, we'll proceed forward. The court notes that the matter that we're taking up here today pertains to both cases. The court is taking up both cases at the same time because the issue that we're taking up today pertains to both cases, and felt in the matter of judicial economy, it made more sense to do them both together. The issue at hand here today is that Mr. Wood, on behalf of the state, has filed a motion to reconsider my order governing courtroom conduct. And the court has looked at his motion as well as his brief. There have been objections that have been filed by Mr. Means as well as Mr. Pryor. Mr. Wright also filed an objection only in the State v. Lori Noreen Vallow Daybell case, and there was not one filed in the State v. Chad Daybell case. So we'll proceed forward. Mr. Wood, this is your motion to reconsider, so I'll hear from you first.
Thank you, Your Honor. I just addressed really quickly why we filed this motion. It's important to ensure that the defendant's rights to a fair trial are protected, and dealing with issues on the front end of a case is better than dealing with them on the back end of a case. And so I appreciate the chance we have to go over this issue now.
Mr. Wood, you're coming through clearly, but it's pretty quiet. Do you mind speaking a little bit louder?
You bet. I'll talk louder. I'd just really quickly like to clarify one thing. In counsel's briefs, it stated that the state has gone on TV in this case. I just want to clarify that the state has never, or I have never gone on TV to present analysis of the facts of this case. I believe that some coverage of Zoom has been lifted and used, but I have never done that. I have never given an interview in this case, and the state has taken steps to ensure that law enforcement follows that same protocol. Rule 45 makes it clear that the decision on whether or not to allow video cameras is subject solely to the discretion of the presiding judge, and that the court may limit audio or visual coverage of any public hearing when the interests of the administration of justice requires. In terms of timeliness of this, I know that was brought up. Rule 45 allows the court to consider this issue and revoke permission to allow audio or visual at any time. And again, for clarity, the state is making a motion solely for the use of video cameras to not be used. We're not asking for a closed hearing. We're not asking for a sealed hearing. And at this time, we're only asking for this in terms of the preliminary hearings that will happen in the next couple of weeks. I'd note that both counsel, Mr. Means and Mr. Pryor, correctly did note in response to my mentioning venue that venue is an issue to take up at a later time. The state's sole reason in mentioning venue is that a change of venue analysis revolves around the possibility of jury bias, which is the reason why the state has brought this motion as well. As stated in the brief I submitted, the state's primary concern in terms of broadcasting video of this hearing or these preliminary hearings on television or the internet, live streaming it on the internet, is that the ease of access to a pretrial evidentiary hearing in a case with such notoriety will cause damage to a jury pool in terms of bias. The state does not believe this is simply a hypothetical issue. The level of public interest in this case is so high that the probability that potential jurors, whatever the venue may end up being, will not be exposed to a production of evidence is unlikely. The state strongly maintains that said exposure to the production of evidence in a courtroom setting not only will create bias in potential jurors, but also the fact that it creates the appearance and possibility of bias is sufficient for this court to consider not allowing video cameras in the courtroom. Now, in reading the media's objection, and I want to state for the record, I have a lot of respect for the media, for these news agencies, and I understand they do a lot of good. And so the state has no problem with the media. However, in reading their objection, the state has done some further research on this subject. And I'd first point out that according to the United States Supreme Court, there is no such thing as a constitutional right to televise inside a courthouse. That can be found in Gannett County versus DePascal, which is found at 443 U.S. at 381. And that can be found in Estes versus Texas, which is at 381 U.S. 532. And in response to the media's objection, the state would encourage the court to review Estes versus Texas, as it outlines the possible dangers of broadcasting pretrial hearings and the bias it can cause potential jurors. In regards to even the possibility of creating bias in a future jury, the state would note the following from Offutt versus United States 348 U.S. 11, when the Supreme Court stated, "A fair trial in a fair tribunal is a basic requirement of due process. Fairness, of course, requires an absence of actual bias in the trial of the cases, but our system of law has always endeavored to prevent even the probability of unfairness. To perform its high function in the best way, justice must satisfy the appearance of justice." The state is mindful of the effects of COVID-19 and the difficulties it raises for all the parties involved. We understand the difficulties it raises for the media in terms of being personally present. However, the public's right to know what happens in this hearing, which is important, and the state absolutely believes in that right, but it is satisfied by the public and the media's access to court transcripts and audio of the preliminary hearing. It's not necessary to live stream and broadcast video of the preliminary hearing when doing so creates such a high probability of affecting future jurors. And so with that, Your Honor, the state would again renew its request that the court not allow video cameras in the courtroom for these preliminary hearings.
Thank you, Mr. Wood. I appreciate your argument. I'll next hear from Mr. Pryor.
Judge, in this particular case, I'd like to clarify a few things. I appreciate Mr. Wood making note regarding the public statements and that he has not made any public statements. It seems that Mr. Wood's argument seems to be centered around avoiding any sort of public display of any of these proceedings, and I appreciate that. My concern is this, is that in all of the historical documents going back to our founding fathers, the very basis of a trial was that it was going to be a public trial, and that the public had a right to see and view the proceedings. And quite honestly, that's still the case today, maybe for different reasons, but it's still the case today. I don't believe we need any more media coverage than we've already had. We've had a tremendous amount of media coverage. I've pointed out that even at the Madison County Courthouse, they've wrapped blue ribbons around the poles around the courthouse and at the prosecutor's office. And that had been there up until late last week. I did notice when I went by there today that somebody took the blue ribbons around. So the argument that there hasn't been already a significant amount of press and a significant amount of media coverage in this isn't going to make any difference. I pointed out in my response, Judge, and it wasn't in the way of an objection to Mr. Wood. It was more in the way of offering the fact that the court, I think, took a deliberate and very thoughtful approach to how they decided to allow the public having their right to view these proceedings. And I think the court took a lot of time and weighed this very carefully when you first made your decision. And I think that decision shows the amount of forethought that this court had. Obviously, the court wasn't aware that the pandemic was going to escalate, and the court making its ruling obviously had the forethought to recognize that maybe that would have happened. And there are two options here. Option number one is to open the courthouse and allow everybody to be present in the courthouse, and my client's family and any other interested parties to be able to offer their support and to be present for the proceedings. Now, obviously, because of the medical pandemic, that's not possible. And we can't in any circumstance risk that sort of situation. So the only other option that I see, Judge, is to do exactly what this court ruled in its initial decision. And I think that initial decision was correct. I think it was done with a lot of thought. And I think at the present time, it's the appropriate decision. And Judge, I would just ask that you allow your initial decision to stand. And I think that's the way we need to proceed in this matter. Thank you, Judge.
Thank you, Mr. Pryor. Mr. Means, I'll hear from you next.
Yeah, just real brief, Your Honor. I think the court's been briefed, obviously, by Mr. Pryor, myself, and the state, and Mr. Wright in this case. I don't think we need to repeat it. I think the ultimate summary is, in this case specifically, I think you could sum it up with the statement of the cat's out of the bag. I think the attention that this case has received as far as media attention, analysis of certain evidence that has been placed in the attention of the media has already occurred. I think the argument to not allow this to be televised is more accurately applied to how can it affect at this point in time with a reservation to challenge venue, how can it affect the citizens of Fremont County? I don't think there's any difference on whether it's televised or not, or how it's going to affect the citizens of Fremont County. Again, I think the point has been made with the media attention to this case that the court has already considered what has happened, what is seen, what has been filed in this court in issuing its initial order. I don't think there's really grounds to reconsider that order or amend that order as is. So our position would be, Your Honor, just to deny this motion and continue forward as the court already issued its order quite a few weeks ago.
Thank you, Mr. Means. Mr. Wright, I've received your motion and your objection that was filed in case number CR 2220-838. I note that it was not filed in the other case of 755 State of Idaho versus Chad Daybell. I've read thoroughly your brief as well as your argument. Is it your intention to make argument here today, Mr. Wright?
Yes, if that's permitted, Your Honor.
Generally speaking, I would allow it. However, I note that there was your filing was very recent, and I understand that everything's been put on fast forward just because the preliminary hearings are fastly approaching. Mr. Wood, what is your position with allowing Mr. Wright to argue beyond what he has filed as far as his objection?
Your Honor, the state doesn't have a problem with it. We may want to respond, but we don't have a problem with it.
Mr. Pryor?
Judge, quite honestly, I wasn't provided a copy of Mr. Wright's pleadings in my particular case. Mr. Wood was kind enough to provide me with a copy, and I had an opportunity to review that. I don't want to delay the ruling by this court. So my position is simply, Judge, that Mr. Wright can stand on his pleadings as they've been presented in both cases. That's fine, but I would prefer that he not make any comment and that we just stand on the documents as they've been provided to the court, and the court make its decision based on his pleadings. For giving him an opportunity to speak, I think would create a situation where I haven't had an ample opportunity to prepare. And I think, quite honestly, that wouldn't be fair to Mr. Daybell. So at this point, it appears that Mr. Wright and I are on the same page in terms of the remedy that we're seeking in our particular case. And I don't want to speak for Mr. Wright, but I think the only opportunity is for the court to live stream these proceedings. And I think that was the gist of what Mr. Wright had presented. So at this point, Judge, my preference is that Mr. Wright be advised that we're going to just review his documents, and then the court can make a thoughtful decision.
Mr. Means, do you wish to be heard on the issue?
Just real briefly, Your Honor, I'm in agreement with Mr. Pryor without regurgitating all the arguments there. My concern would be if he's not allowed to voice argument today, that this matter will be pushed and might interfere with the scheduling of the preliminary hearings. So at this point, no objection.
Mr. Wright, I'm going to allow you to do this. I'm going to allow you just a few minutes here to highlight some of your bullet points. I do feel that giving you a lot of time to argue is prejudicing Mr. Daybell because he was not provided with information regarding to your argument. If you want to make a few bullet points, I'll allow you to do so. Otherwise, I'm going to deny your ability to make argument today for the reasons I've just outlined. Do you wish to make a few points?
Of course, Your Honor, and I appreciate the comments of counsel and the court's consideration. I'll be very brief. The first point may be just to help explain the clerical issue here. I became aware of the issue specifically on Thursday, and I was only aware of the motion filed in Ms. Vallow's case. Hence, I drafted and submitted my brief the next day in relation to that. However, my arguments I would submit are applicable to both, Your Honor, and would ask for the same result. I won't repeat what is in the brief. The court's well aware of that. To the extent that the state has cited new cases, however, if the court believes those are worthwhile and have merit in terms of changing its order, I would respectfully request the opportunity to respond to that, given that they were provided only at this time. Your Honor, I'll just briefly summarize it by saying that we believe that the video feed is really the very appropriate solution, balancing all the factors in this case. It's the least intrusive method. It is a way to provide accurate information. And as I cited in the brief, publicity itself is not a bad thing. In fact, it's a good thing. The concern is bias arising from inaccurate information. And there is no better way to make sure that accurate information is provided than through a video feed. The state, who I would say that the media reciprocates and does not doubt the respect that the state has indicated exists here for the media, that is reciprocated. We just believe the approach sought is incorrect here. And the indication is, well, that information can be obtained after the fact through audio and transcripts. That accomplishes nothing other than interfering with the media's ability to try to provide appropriate coverage in this case, coverage that will occur. And so we believe that hindering it by referring after the fact to that information accomplishes nothing that will address the state's concerns. Let's see if there's any other comment. I want to be brief as the court has requested, see if I have any other comment. I guess, Your Honor, I would just say this. We do understand that this is under Rule 45. We understand the context of the Supreme Court cases cited by the media as well as by the state. We all know that none of those dealt with our circumstances as they are now. The idea of the fact that this virus has created the conditions that it has is unfortunate, but only lends itself to the idea that video here is the best way to address this situation and to balance all of the factors that we believe are necessary. And so, Your Honor, I realize this is brought under 45, Rule 45, but it does by definition include serious constitutional issues, because in this case, shutting off the video feed is effectively the same as closing the courtroom, even if transcripts may be available later. I thank you, Judge.
Thank you, Mr. Wright. Mr. Wood, this is your motion. I'll give you the last word if you'd like it.
Just briefly, Your Honor, I'd point to the fact that the United States Supreme Court right now even with COVID, they are not live streaming. They don't allow video cameras. So there's at the highest level of precedence for this information to be distributed by other means. And that's all I'd state, Your Honor, and we renew our request. Thank you.
Thank you. Mr. Pryor, I designated that if there was something that you wanted to respond to, because Mr. Wright was given a chance to speak, I'd allow you to do so. Anything else you'd like to say?
Just simply, Judge, I agree with Mr. Wright in the sense that a defendant has the right to a fair public trial. And I agree with Mr. Wright that under normal circumstances, Judge, my preference would be that this hearing, this preliminary hearing, would be done with the courtroom opened, and those that felt the need to participate and show up would have a chance to view that. And unfortunately, Mr. Wright pointed out that that isn't an opportunity for us. So I think the only alternative at this point is to stream this. And as far as what Mr. Wright said about giving the opportunity for the public to view something, a videotape after the effect or a transcript after the effect doesn't accomplish the same thing. Quite honestly, the public has a right to see this. I would prefer that it was done in a courtroom and not on a live stream, but the public has a right. And we as much as I want to be aware of Mr. Daybell getting a fair opportunity for a fair public trial, I believe that your initial decision was well thought of and well based and should probably stand at this time. Thank you, Judge.
Thank you, Mr. Pryor. Mr. Means, anything else to add?
No, Your Honor, I think the only thing I'd add is in the court's analysis, I think given the media coverage of this case already, the public's right outweighs the potential argument of fairness for the defendants in this case.
Thank you. All right, the court has listened carefully to the arguments that have been made by the state counsel for both defendants as well as counsel for the media. The court has done its own research in preparation for today's hearing. The court is appreciative of the fact that Mr. Wood, on behalf of the state, has filed this motion. The court feels that it's genuine, and ultimately Mr. Wood, as the state or the prosecuting attorney, does have a right to seek justice. And I feel, based upon the motion that has been filed, that ultimately Mr. Wood is doing all that he can to preserve justice and preserve the right to a fair trial. The court has listened carefully, and I'm prepared to rule from the bench on this matter. I will issue a written decision later, but I am going to issue an oral ruling right now from the bench and then follow that up. I'm aware of the defendant's rights to a fair trial in Idaho, or Article 1 of the Idaho Constitution and the 6th Amendment to the United States Constitution. The court also recognizes the First Amendment rights of the press and public access to the courts. This is a high-profile case, and people have a lot of feelings about it. It is a priority for the court to be transparent in its process so that the public can be assured of the fairness of the judicial system. The public has a right to access court proceedings and should have the ability to scrutinize the court proceedings, even scrutinize what each of us do in our own roles here in the judicial process. The court has looked at various ways to balance the constitutional rights of the defendants as well as the public's right to know. COVID-19, the coronavirus, is an unprecedented global pandemic that has impacted the government and subsequently impacted the judicial system here in the United States and here in Fremont County, Idaho. Federal and state governments have put in numerous procedures and protocols in place and orders to protect the public at large. The Idaho Supreme Court has issued numerous orders, but 2 are relevant specifically to the proceedings that are forthcoming, the preliminary hearings. The first was issued on April 22nd, 2020. This order requires court proceedings be held remotely unless, quote, a proceeding must be held in person because of the court's need or to prevent undue prejudice to a party. If a hearing is held in person, access to the public needs to be drastically limited to prevent the spread of COVID-19. I will designate that in my previous order, I designated that this was a case that needed to be held in person. I don't think the state objects to that. The state objects to it being broadcast and live streamed because of the potential prejudice or tainting of potential jurors here in Fremont County. The court has installed plexiglass here in the courtroom and is doing all that it can to promote the safety of anybody that is involved. But ultimately, I've already found on the record and in my pleadings that it does need to be held in person to prevent undue prejudice to both defendants that are here in this case. I also note that I need to drastically limit the public's access to prevent the spread of COVID-19 pursuant to that order from the Idaho Supreme Court. The second order from the Idaho Supreme Court was issued July 24th, 2020. This order has postponed all jury trials until September 13th. It also places additional restrictions on public access, including health screening, social distancing, and the use of a mask. This order also states that the proceedings, quote, may be live streamed in lieu of allowing the physical presence of the public only when, number one, the assigned judge finds that health and safety concerns override other interests in allowing the public to be physically present in the courtroom. Number two, denial of the public's physical presence in the courtroom is necessary to protect the health and safety of those participating in the proceeding, including a lack of sufficient physical space or adherence to required social distancing. Number three, the assigned judge has considered other reasonable alternatives to allow for the physical presence of the public. And number four, the assigned judge has found on the record that live streaming is an appropriate alternative because A, no reasonable in-person alternative is available that would sufficiently ensure the health and safety of those participating in the trial, and B, the available live streaming capability is narrowly tailored and a reasonable alternative. The court has looked at possible ways to narrowly tailor public access to ensure that regulation of the First Amendment rights is no broader than necessary to serve a substantial governmental purpose. This has been done through the following measures. Number one, only allowing one media outlet in the courtroom to broadcast the preliminary hearings, as well as one outlet to photograph the proceedings for the preliminary hearings. Number two, preventing the audio and visual broadcast of conferences between attorneys and their clients and between counsel and the presiding judge. Number three, preventing the visual broadcast of any documents, exhibits, or notes in the attorney's possession until they are admitted into evidence. And number four, preventing audio and visual broadcast of off-the-record sessions or judicial deliberations. The court finds no other viable option beyond allowing one news media outlet to broadcast the preliminary hearing and one media outlet to photograph the preliminary hearing in order to protect the public from the spread of COVID-19 while still guaranteeing their constitutional rights. As Thomas Jefferson said, quote, our liberty depends on the freedom of the press, and that cannot be limited without being lost, close quote. I'm denying the state's motion to reconsider my order governing courtroom conduct. Things will proceed as outlined in my July 8th, 2020 order governing courtroom conduct and the subsequent order in the subsequent case of Miss Daybell. Mr. Wood, do you have any questions about my ruling here today from the bench?
No, thank you, Your Honor.
Mr. Means, any questions?
No, Your Honor, thank you.
Mr. Pryor?
No questions, Your Honor. Thank you.
Mr. Wright?
The only question I have, Your Honor, and again, please excuse my lack of knowledge because I wasn't involved before, but by denying the motion to reconsider, as I understand it, the court is not changing what it had previously ruled in terms of structure and who has access and who does not. Is that correct, Your Honor?
That's correct. And let me clarify and be very clear. I'm relying on my order governing courtroom conduct that was issued in both cases, State v. Chad Daybell and State v. Lori Noreen VALLOW Daybell. I'm also noting for the record that subsequent order that was issued by the Supreme Court just recently, it was issued on July 24th, only a few days ago. Obviously, that order would play a role in how we proceed as well. It shouldn't affect the preliminary hearing to a great extent, but in the event that it does, we'll need to follow that order as well on behalf of the media and access. Any other questions, Mr. Wright?
No, thank you, sir. I appreciate the clarification.
And just so it's clear, I'm denying the motion to reconsider in both cases, and my ruling will stand in both cases. be in recess right now. Thank you all for appearing.
Thank you.
Thank you, Your Honor.